Right now, an artificial intelligence model can generate a completely groundbreaking algorithmic framework or, a highly specific piece of software architecture in what, maybe 2 seconds?
Oh, easily. Sometimes even less.
Right. But do you know how long it takes to actually legally protect that code through traditional intellectual property channels? We are talking easily 2 to 3 years.
Yeah, the timeline is just totally broken.
It really is. And think about it. Have you ever been in one of those really energetic brainstorming sessions with your team? Whiteboard markers are flying everywhere. Someone is mapping out an entirely new product logic.
Oh yeah, the classic war room scenario.
Exactly. And
Yeah.
then you realize that as soon as you wipe that board clean, you have zero proof you actually came up with any of it. We're looking at this massive temporal collision right now that is just breaking the modern business world. So today we're doing a deep dive into a launch announcement from a platform called Instant IP.
Right, they just rolled out a major upgrade, I think.
Yeah, it's called Instant IP Teams. And the whole mission of this announcement and our deep dive today is to look at how this platform is designed specifically to patch this massive vulnerability between how fast we create and how agonizingly slow it is to protect it.
Which is so critical because that friction between the speed of modern creation and the speed of legal protection, I mean, it is the defining bottleneck for innovation today.
Okay, let's unpack this. Because the core problem here outlined in the text isn't just that, lawyers take a long time to answer emails, it's a structural failure.
Right, the traditional system is incredibly siloed, it's manual, and it's shut-loaded with massive costs. We operate in a system where the U.S. Patent and Trademark Office, and really its global equivalents, they're burdened with these massive structural backlogs.
Which kills momentum.
Exactly. You have this incredible momentum when generating a concept, but the moment you try to secure it, you just hit a bureaucratic brick wall. And we need to elevate the stakes here for the listener beyond just administrative annoyance.
It's because it hits the wallet.
Precisely. Whether you are a solo founder or sitting in a massive corporate R&D lab, this directly impacts your bottom line. Because since the America Invents Act shifted the U.S. to a first-to-file system, which aligned us with the rest of the world, by the way, the timeline is absolutely everything.
So it doesn't matter if you invented it first in your garage.
No, not at all. It is no longer about proving you had the idea first. It's solely about proving it to the patent office first. So while you are assembling prior art, paying thousands of dollars in filing fees, and basically just waiting in an administrative queue, your fragile early-stage idea is highly vulnerable.
It's basically like leaving unprotected currency just lying on the sidewalk.
That is exactly what it is.
And that structural vulnerability requires a totally different approach to how we handle ideas in the wild. There's this great quote in the launch announcement from Kerry Oberbrunner, the founder of Instant IP. He says that intellectual property is no longer created in isolation, it's created across teams.
Which is a huge paradigm shift.
Right. To understand this new platform, we have to grasp that the very nature of innovation has changed.
Yeah, that represents a fundamental operational shift. I mean, the mythological lone genius having a eureka moment in a dark room, that is an outdated model.
It really doesn't happen like that anymore.
No. Today, innovation is this decentralized, highly collaborative ecosystem. You might have a developer in Austin writing the code, right?
Yeah, and maybe a designer in Berlin mocking up the interface.
Exactly, and a strategist in Tokyo
Right.
finalizing the market positioning, and they're all operating simultaneously on the exact same core concept.
I always used to think of traditional IP protection as like taking a photograph at the finish line of a marathon. The patent is the photograph.
Oh, that's a good way to look at it.
Right, because it proves you won the race, it gets recorded in the history books, but it doesn't show how you actually ran the race. If someone challenges your time, all you have is that one snapshot.
And that snapshot doesn't tell the whole story.
Exactly. But modern innovation is more like building a spaceship mid-flight. You can't just wait until it's finished to protect the blueprints. So what Instant IP Teams seems to be doing is acting more like a biometric fitness tracker that's running the entire time.
Right, it's logging the whole journey.
Yeah, it's logging every heartbeat, every step, every elevation change in real time. So if someone claims they ran the race for you or that they, stole your pacing strategy, you have this irrefutable stream of data proving your exact path from start to finish.
What's fascinating here is how that shifts intellectual property from a static post-creation legal hurdle into a dynamic team-based management system. The text uses this phrase, protecting ideas at the speed of thoughts together.
At the speed of thought. That's ambitious.
It is, but when you analyze the mechanics of that, you realize businesses are being forced to stop treating IP as this annoying chore you just hand off to outside counsel once a project is totally wrapped.
Right. It can't be an afterthought anymore.
No, organizations have to start managing it as a living, breathing asset alongside the very people who are actively iterating on it.
Okay, but functionally speaking, if the philosophy is protecting ideas at the speed of thought, how does the technology actually organize all that chaos? Because if everyone is throwing every half-baked thought, brand asset, and beta code into a single collaborative system, how do you prevent that from turning into just a totally useless, unsearchable digital dumping ground?
Yeah, that is the risk with any high-volume data ingestion.
I mean, if the architecture isn't built for logic, you aren't actually protecting anything. You're just hoarding disorganized data in a big digital drawer.
Without a rigorous architectural hierarchy, you just create noise. So the platform attempts to solve this structural chaos through a feature they call IP portfolios.
Right, the custom collections.
Exactly. Instead of a rigid linear filing system that mimics a law firm's ancient server, users can build custom collections that mirror actual business operations.
The text mentions a few specific examples of this, like a company might configure a dedicated portfolio for brand assets and a separate one for client work.
Or even establish something highly time-bound and specific, like Q1 product filings.
Here's where it gets really interesting, though. They claim to eliminate file duplication by allowing a single asset to live simultaneously across multiple portfolios.
Right, which solves a huge administrative headache.
Yeah, so a specific proprietary logo file isn't just trapped in the brand assets folder, it can natively populate in client work too. But I have to push back with a practical question here.
Okay, lay it on me.
How do you share this stuff without giving away the keys to the kingdom? Like, if I have an incredibly valuable piece of IP, let's say the core machine learning algorithm for our new software.
The crown jewels, basically.
Yeah, exactly. And it's accessible through a joint venture portfolio because we're co-developing an offshoot product. How do I share the branding assets with that external partner without accidentally giving them the source code?
Yeah, that's a very real concern.
Because I want them to see the packaging, but definitely not the proprietary formula.
You are hitting on the exact friction point of any collaborative enterprise software, which is the tension between seamless access and rigorous security. The mechanism the text details to solve this is a strict bifurcation of public and private environments at the architectural level.
Okay, so they separate them out entirely.
Right. You have public portfolios, which function as highly curated presentation layers, so you can select very specific non-sensitive assets, like those branding materials you mentioned, and generate a secure external link.
And the partner only sees that.
Exactly. The joint venture partner only sees that curated gallery. Meanwhile, the actual underlying proprietary algorithm remains siloed in private assets, completely invisible and inaccessible from that external link.
So the architecture natively understands the difference between the presentation gallery and the vault.
Yes, that's a great way to put it.
You're never actually moving the sensitive file into a shared folder where it could be compromised. You are just granting temporary, localized visibility to specific, safe elements.
Precisely. And if you think about the operational drag this eliminates, I mean, teams aren't emailing version 6 of a sensitive file back and forth.
Oh, I hate that. Final version 2.pdf.
Exactly. They aren't trying to remember who has view access to which generic cloud drive, and they aren't creating a dozen copies of the same asset across different local hard drives, which, by the way, is a massive liability in terms of legal chain of custody.
Okay, so organizing files and preventing duplication makes sense. But the moment you invite 30 different human beings to collaborate on sensitive intellectual property, you introduce the human element.
The wildest card of all.
Right. Someone gets careless, they click the wrong button, and suddenly the primary schematic for your flagship product is just deleted. Or even worse, you face the threat of disgruntled employee sabotage. How does the platform handle the reality that people make mistakes or act maliciously?
Governance protocols are absolutely mandatory in an environment like this. The platform institutes what they call IP team collaboration, which is governed by sub-users and permissions.
The text highlights that there are 4 distinct levels of role-based permissions, right?
Yes. This isn't a flat hierarchy where everyone just has blanket administrative rights. It scales from view-only access, where, say, a temporary contractor can merely look at an asset to verify a detail.
all the way up to full administrative control for the primary executives.
Exactly.
I have to say, I hear 4 levels of role-based permissions, and I immediately think of every bloated corporate enterprise software I already hate using.
It sounds heavy, I know.
Yeah, does this actually speed up innovation, or does it just add another layer of bureaucratic red tape for creatives who just want to brainstorm without requesting IT approval for every little thing?
Well, it actually removes friction if implemented correctly,
Yeah.
because the alternative to automated permissions is manual oversight, which is infinitely slower.
That's
But the permissions aren't even the most crucial mechanism here. If we connect this to the bigger picture, the real legal weight comes from the built-in activity logs.
okay, so I assume we aren't just talking about a basic timestamp like a Google Doc version history.
Oh, far from it. In the context of intellectual property law, proving prior art, which means proving exactly who created what and precisely when, that requires absolute verifiable certainty.
Right, because millions of dollars could be on the line.
Exactly.
Mm.
An activity log in this context acts as an unalterable digital fingerprint. When an asset is logged, or when a modification is made, the system doesn't just record a time. It is creating a transparent, cryptographic ledger of the event.
So it's locked in.
It's locked in. So if a legal dispute arises 2 years down the line because a former employee claims they invented a specific feature, you don't have to piece together a chaotic timeline of deleted Slack messages and local server backups.
You actually have an objective record.
Yes, an unalterable chain of custody that legally establishes the origin and evolution of the idea.
It essentially automates the creation of prior art. You're generating a legally defensible paper trail in the background without requiring the engineers or the designers to stop what they are doing and document everything manually for the lawyers.
That background automation is exactly why the target demographic for this spans such a massive range. Because the operational burden of IP management, it hits everyone who creates value.
Let's talk about that scale, because who is actually using this? The list of intended users in the announcement is pretty staggering.
It really covers the whole spectrum.
Right. They are building this for massive corporate legal teams who are managing high-volume, complex IP portfolios across global subsidiaries. They are targeting dedicated innovation and R&D departments.
Yep.
But then it scales all the way down to a 3-person startup operating across different time zones, or even boutique agencies creating shared IP with their clients on a daily basis.
Well, the volume of creation might differ significantly between a Fortune 500 company and a seed-stage startup, but the fundamental vulnerability really does not.
If anything, it's worse for the little guy.
Exactly. In fact, if a core product concept leaks before a patent is filed, the startup is actually at a much higher risk of total catastrophic failure than the corporation.
Because they lack the legal war chest to fight it out in court for 5 years?
Precisely.
So what does this all mean for the advisors? The legal professionals who have traditionally been the gatekeepers of this whole process. The text specifically mentions a group called Instant IP Advisors. Are these just law firms licensing the software, or does this actually change their whole business model?
It forces a complete modernization of their value proposition. Historically, the relationship between an innovator and an IP attorney was heavily administrative and, honestly, largely reactive.
Right. The client does the creating, hands over a messy pile of documentation, and the attorney formats it into a rigid application.
And then files it with a slow-moving government body. It is highly transactional. But by integrating an advisory track into the platform, law firms and specialized agencies can transition from being post-creation administrators to real-time strategic partners.
Because they have access to the dashboard from day one.
Exactly.
They aren't waiting for the finish line photograph we talked about earlier. They are monitoring the biometric data while the race is actually being run.
They can offer proactive structuring. They ensure that as a company iterates rapidly, the underlying assets are organized in a way that will actually streamline the eventual formal registration.
That makes so much sense.
They can flag potential legal conflicts early, they can advise on strategy in real time, and they significantly reduce the billable hours spent just untangling a client's disorganized digital files.
Which brings us to the elephant in the room, the underlying catalyst driving all of this urgency. Because why is a real-time automated prior art generator so urgently necessary right now?
Right. Why today?
Yeah, we have managed to limp along with the traditional system for decades. People have always collaborated on teams. But the source text points to one massive technological catalyst that has fundamentally shattered the timeline.
The velocity of output has completely decoupled from human limitations.
We're talking about the world of AI. The platform is explicitly positioned as being designed for the world of AI.
Which changes everything.
It really does. When an engineering team uses a large language model to help generate complex novel code, or a design team uses image generation to iterate 1,000 variations of a product prototype in a single afternoon.
The sheer volume of intellectual property being created is staggering.
Exactly. The traditional multi-year waiting period to get a piece of paper from the government protecting something that was generated in 30 seconds is functionally absurd. You can't file 1,000 separate patent applications for a single afternoon of AI iteration.
It is a profound structural mismatch. The legacy legal system operates on analog, bureaucratic time, but modern creation operates on generative AI time.
Yes.
This raises an important question, though. What is the actual legal standing of a platform like this? Are they claiming to sidestep the United States Patent Trademark Office entirely?
That is the vital distinction they make in the text. Oberbrenner clarifies that instant IP teams is absolutely not replacing the existing legal system.
Okay, so it's not some rogue, unrecognized sovereign patent office trying to rewrite federal law.
No, not at all. The ultimate goal is still to secure those formal government registrations because, as you know, that is what ultimately holds up in federal court when push comes to shove.
Right.
Instead, they describe this as providing an immediate, verifiable layer of protection. It is a bridge concept.
A bridge, I like that.
The AI era has widened the danger zone, right?
Yeah.
That massive gap between the split second of creation and the years of waiting for formal registration. So this platform builds a highly secure, heavily documented bridge across that gap.
So you get your verifiable timestamp and your unalterable log the very second the AI outputs the code.
Or the second the human writes the algorithm.
Right, so you can safely utilize the idea in the marketplace while the slow machinery of the government processes your formal application.
It basically ensures that the speed of your innovation isn't brutally penalized by the speed of the bureaucracy.
Which is a huge relief for creators.
Let's look at where we've landed on this journey today. We started with a massive temporal collision between the breakneck speed of modern creation and the sluggishness of legacy IP law.
We explored how Instant IP Teams is attempting to shift the paradigm by moving away from isolated static legal filing and toward dynamic, team-based management.
Exactly. And we dug into the functional mechanics, how multi-use portfolios eliminate file duplication while safely separating public and private visibility. We looked at how robust permissions and cryptographic activity logs automate the creation of legally defensible prior art.
And finally, we saw how this entire architecture acts as a vital bridge, keeping ideas safe for businesses operating at the bleeding edge of generative AI.
So, if you are listening to this and you're mapping these vulnerabilities onto your own workflow, or maybe you are a legal professional looking to modernize your practice, there are specific destinations provided in the text to explore.
Where can they go?
You can visit instantip.today to learn more about the broader philosophy and technical specs. If you want to deploy the software for your own collaborative team, you can start using it at instanttip.app. And for the advisors, the agencies, and the law firms looking for that strategic partner track, you can find that at instanttipcertification.com.
You know, we have spent this deep dive primarily focused on the mechanics, the legal friction, and the technological solutions. But I want to leave you with a final thought regarding the human element.
Okay, I'm intrigued. What are you thinking?
Well, think about it like this. If a platform can provide an immediate, verifiable timestamp of your collaborative thoughts the very second you generate them, how might that fundamentally alter the psychology of creation?
How do you...
Currently, we tend to treat raw ideas as inherently cheap or disposable until they have been, proven out, refined, and formally protected. But if the very act of capturing an idea instantly transforms it into a logged, secured, and verifiable asset, does it change how seriously a team treats their own brainstorming?
Oh, wow. I never thought about that.
Does it elevate a fleeting thought into a tangible piece of intellectual property before it is even fully formed? It's a fascinating psychological shift to consider the next time you're standing at a whiteboard, marker in hand, generating the spark of something entirely new with your team.
The moment it is logged, it becomes real. That might just be the most powerful transformation of all.